Good afternoon. I'm Chris Carr. I'm a partner at Paul Hastings in San Francisco, lawyer, longtime student of Harry's. Have known him since 1987. What I do now is I get big utility scale wind, solar, battery energy storage projects built, defend them in litigation, all the permitting. But a number of people mentioned sort of central insight of Harry's is the intersection of law, science, and policy. A number of people mentioned that. That's really propelled me, the interest in that throughout my career, and even today, in my work as a lawyer. So those insights learned from him have been absolutely formative for me, as I know there have been for so many of us here. Also want to make a special note that Harry was really like a second father to me. There's really no one who was more influential in the trajectory of my career and frankly my life. And Jane, his beloved wife and academic collaborator, was there every step of the way too. So they're just a wonderful, wonderful team, as you know, and she's of course sorely missed. But just to make it real quick, met Harry in fall 1987. I was just an undergraduate, history major, didn't know what I was doing. Went to this office up at the law school, knock on the door. Person very gruffly answers the door, sort of lets me in, essentially said, "What do you want?" After I navigated my way through the piles of books in the office, was able to, he could sit down, I couldn't sit down, but I said, I'm in American history and interested in this course. And he immediately said, well, you should know there's about 500 pages of reading a week and several major essays and the final exam. And that was about it. And I left and I'm thinking to myself, what's going on here? This person isn't very receptive. I later learned from the teaching assistant, Carol Brownstein, wife of our colleague David Lieberman, who recently passed, that Harry was trying to scare me off. And it wasn't just me he was trying to scare off. This was a methodology he had that came from the right place, of course, right? Because if you were his student, he wanted you, frankly, to be passionate about what you were doing, just as he was passionate. And he conveyed that to all of us. And so that was wonderful, Catherine, to hear you mention that. Frankly, Commander, you remember his last ocean law and policy course and the very good question and very last day of the class. I was lucky enough to be the guest lecturer. And people asked sort of like, what's your advice? Like, what is it? What's the key to success? And he talked about passion. He said, at the end of the day, you got to love what you do. And don't care what other people think or do, just pursue your passion. And so that advice has propelled me individually. I've conveyed it to others. I attribute it to him. But I know we all share in appreciating his sage advice over the years and direction. I could go on and on. I'll try not to do it too much. I got my PhD under him. My primary source material came from when I worked at the State Department in international fisheries. He got me that State Department fellowship. It's the best job I ever had. To this day, I say that. My dissertation wasn't filed until I was a partner at a law firm in 2004, and I was struggling to get it done. And he just finally said, Chris, you're a litigator. You know how to move paper. Just get the damn thing on file. And stop worrying about it. So I could just go on and on, but the wonderful man, incredibly generous, and has just had a huge influence on all of us here, personally, professionally, and was light years ahead of so many in foreseeing the emerging issues in the law of the sea and marine conservation before they became de rigueur. And so just want to thank him for all that he's done for me individually and for all of us here, and really for the entire field. And with that, let me introduce our first speaker on the panel, Climate Change and Law of the Sea and Conservation and Sustainable Use of Living Marine Resources. Professor Vasco Becker Weinberg, founder and president of the Portuguese Institute of Law of the Sea, professor of Faculty of Law, Universidade Lusafona, and at Nova School of Law, widely published in the field, and has served on numerous international delegations for Portugal. Professor.
Thank you very much for that introduction, and good afternoon to all of you. If I stop making sense, please blame the jet lag for that. But definitely where I will make sense will be in my remarks to thank the kind invitation and generous invitation to be here today with you to honor Harry Scheiber. I met Harry and Jane and most of you, the LOSI family, in 2010 or 2011 in Seoul. I was a PhD candidate at the time, and that was a life-changing event. Many of you that I know that are here, I met there at that time, and we all became friends. And usually in Portugal, you say that you should age like port wine. But if you to recognize the historian attributes of Harry, actually Harry is not so much as a port wine, but like the Declaration of Independence of the United States, a fundamental text, but still problematic. What glued it together was the fact that the founding fathers celebrated the Declaration of Independence not with port wine, but with Madeira wine. And that actually, probably Harry is more closer to Madeira wine than port wine. Of course, Dr. Kwan and KIOST for everything they do to make these meetings possible as well. And of course, Clee and Louise, specifically Maya, Tony and Charity Lee, of course. And it's interesting to see that I'm also here with Sherry, and Sherry actually moderated that panel for young researchers. I'm still a researcher at heart, not as much as young as I would like to be. And the topic of my presentation will be on sea level rise. And there, of course, I have to also remember, because the work that I've done on sea level rise is connected with the work that many of us in this room are doing, particularly Clive and Sequel Lee as well, on sea level rise in the Sea Level Rise Committee at the ILA. And unfortunately, one was a magnificent meeting that we had in Lopud in Croatia. Was also the last time that most of us, if not all of us, saw David Caron. But to lighten the atmosphere, we all had to take a small vessel from Lopud to Dubrovnik. And everybody got sick except David Caron, because he was the only sea person. So while everybody was getting sick, everybody was passing the bags to David. And David was just getting rid of them and just trying to keep all of us afloat. So there you go. Anyway, so let's talk about something not as interesting, perhaps, as all of these many important stories that actually are the fabric of friendships and the law of the sea community. That's more of a family than a community, and that's quite unique in international law. Most of our colleagues that study international law, they go to these international law meetings and they always come back and they're extremely boring. And I'm always very happy to say that, first of all, our venues are amazing. And second, that the friendships that we've built over the years are extraordinary. And that's a legacy that we carry from people like the seminar that I've mentioned, but we should also carry towards the next generation. So, on the issue of sea level rise, I would like to focus specifically on the relationship between sea level rise and dispute settlement. Not so much on issues of led referenda, but looking at what these issues might be in 2023, 2024. Of course, the moment is ripe because we are seeing now the beginning of an advisory opinion processes that will be very interesting to see what will happen, what meat will be fleshed out of these the questions that were asked to both ITLOS and the ICJ, and how they will actually interact between each other, if there will be any interaction at all. But I would like to focus on two perspectives. One, what on judicial adjudication, what would be ultimately the perspective of a court regarding dispute settlement and the applicability of rules and methodology for maritime delimitation. And the second one, a more complex, perhaps, perspective, that of the relationship between sea level rise and the effects on existing maritime boundary treaties, and try to draw some conclusions. First of all, looking and trying to give you some background, of course, in this room that would be unnecessary, but still from the question of form. Boundary in international law is a complex issue, as we are all aware, because there's always difficult principle established under international law that boundaries are there to stay. It's really the only issue that cannot be revisited under state succession. And that is quite a strong obstacle when we talk with, specifically if you have the opportunity to meet states that have succeeded other states that negotiated the boundaries. This is always something that they carry with them. I could mention a few examples how these things can be extremely difficult from a political and diplomatic point of view, but still this is what we have, and this is the reality we have to deal with. However, that is on the basis that the existence of these boundaries offer legal certainty and legal security. And that was the perception when this practice developed and then was very much enshrined in this notion of state succession. However, this is not the case with sea level rise. There, one could raise the same concerns about security and certainty with a boundary that does no longer reflect its relationship with the terrestrial with land. So therefore, sea level rise is an issue that is quite important to consider, particularly in light of existing legal rules and not merely looking at an issue of lege ferenda. As I mentioned, this is very much the outcome of two working groups, one at the ILA, but also one at the ILC, that have been looking at some of these issues. I will not, for the sake of time, I will not delve into much of these intricate details because they're also available on the reports issued by both ILA and the ILC. But I will just highlight that there is what is the expression you have in the United States? The jury has not come out yet. What do you say? The jury is not out yet. So and this is something that we probably will not see established or fixed in our lifetimes, perhaps, but for sure this is something that is a legal reflection that is ongoing and will be formative in the future. With respect to what actually matters, looking at UNCLOS, for example, is that either way, should you be inclined to freezing baselines or maintaining outer limits, being you inclined for one or the other, in both situations, you are putting at risk established rules under UNCLOS. And I highlight here 4 examples. First of all, the notion of permanency that is specifically referred to as such in UNCLOS. So therefore, reinterpreting this idea of permanency in the convention in itself might be a mission impossible. So therefore, that will be a major obstacle for any of both solutions. The other one is how shifting baselines would be maintained in the case of unstable coastlines. Third, how the idea of submergence of base points would therefore continue to supplement the land water to land ratio in the case of archipelagic states. And lastly, the status of offshore features, because that in itself, what we could see from the South China Sea, well, reiterated in the South China Sea arbitration, because there had been writings before that, of course, it's not ground zero in terms of legal creation when it comes to islands and offshore features. But that in itself would raise issues as well. So therefore, regardless of the outcome you might find in freezing baselines or maintaining outer limits, at least in these 4 instances, you would have a problem in interpreting and applying the existing rules under the convention. Of course, the main issue is that the sea level rise, very much like climate change, were not on the agenda back in the 70s when the Law of the Sea Convention was being discussed. Not that we were unaware of climate change, not that we were unaware that sea level rise was a possibility. There was already data to that respect, but it was not on the legal agenda of issues that was debated. It was not within the package deal. And now what we're seeing exactly with the advisory opinions is trying to reinterpret certain definitions enshrined in the convention that that might be problematic, namely the case of pollution. So I got the only moderator that will stick to time. Of course, it's a lawyer. He charges by the hour, so it makes sense. Anyway. So the question is how to settle this issue and trying to how we settle this issue in the case that we might have an adjudication where this issue is risen and has been risen, and the other one is how to deal with maritime boundaries. And the only way that we could challenge an existing maritime boundary would be, of course, by resorting to legal rules. And that, of course, would be the Vienna Convention on Law of Treaties and recognition if there would be a fundamental change of circumstances. Again, a complex legal approach to a complex issue. First of all, we have to consider when do we have a dispute? The fact that there is sea level rise or there are effects of climate change vis-a-vis a maritime boundary, is that sufficient to meet a threshold or the test of existing of a maritime dispute? And in this room of august jurists, I will not delve into the notion of when do we have a dispute or when that dispute emerge, and I'll move forward for the sake of time. The other issue is, can international courts and tribunals adjudicate a dispute regarding a future event? That in itself is a very complex issue, and it's an issue of substance. Can a court establish a reasoning, a line of thought for an issue that will only be, there might be a dispute, but it will only be solved in the future? If we would make a parallel track to this complex issue, we look at the relationship, for example, between international adjudication and other bodies, namely the CLCS, where there has been some sort of interaction, but we are dealing with very limited timeframes when compared with the effects of sea level rise. And then the other issue is sea level rise in itself is a continuous process. We know, we can see it shifting, but we do not know when that shift will end. And therefore, those are also complex issues. We have 2 cases where we might see this in the fisheries jurisdiction and in Nicaragua and Honduras. And I'll come back to Nicaragua, by the way, at the very end of the presentation, so stay tuned for that final comment. But what we can see here is that the courts have not really considered these similar aspects of uncertainty relevant for the purpose of coming to a final decision. Of course, then we have the issue of resorting to exequat bono, should the states agree to. But again, even if we would resort to exequat bono, would that actually be a decision that would be future-proofed? Because it is a rule, of course, that does not exist. So that in itself is another problem. So let's look at one case where the states did try to make, or one of the states raised the issue of sea level rise. In the case between Bangladesh versus India, the issue was risen, but the court did not, the tribunal did not really lose much time with it. And you can just see the cruelty of the wordings in red, and you can actually see how the court was very quick not even to consider this. However, since the Bay of Bengal arbitration, a lot has changed. the perception, the work that has been done by jurists on the issues of sea level rise has at least doubled over these years, and therefore, since the sensibility regarding this issue has changed as well. So let's look at the Vienna Convention and see how this would actually work. Again, the Vienna Convention, although it does refer to fundamental changes of circumstances, it does clearly state that it may not be invoked as a ground for termination if the treaty establishes a boundary. So there again, we would have another obstacle to the possibility of changing a boundary line. So where does that leave us? It doesn't leave us in very safe grounds, because if we would look at the interpretation of Gavichukov and Nagimaru's case and the Aegean Sea continental shelf, the perception of what is a change of circumstances has been established under international law. Could we revisit these understandings? I would say no. It would not be possible to do so without assuming that there is a significant change in international jurisprudence. Having said that, however, if we look at a recent case by the ICJ, particularly Nicaragua versus Colombia, and the whole notion of customary international law, we can see that the ICJ has taken, how could I say this politely, has gone into uncharted territory when it comes to revisiting what was now very much a peaceful understanding of what constitutes international customary law. The Center for International Law in Singapore actually just had an event, or will have an event, the title of which says the secret customary law. And that actually is what the court in this paragraph came to a conclusion. What is the relevance of this vis-a-vis the topic of my presentation is that although we may speculate and come to tangible conclusions and reasonable and legally sound conclusions to what would be the correct interpretation of the existing rules of international law, there's one issue that for sure we cannot anticipate, and that is the legal creativity of international judges. On that note, I will end without any conclusions because I do not have much more time, and I am receiving threatening looks from the moderator, and I'm too tired to fight him off due to the jet lag. But anyway, on that spirit, I will just say that this is, of course, an important issue. It's one that will of course, be on the agenda for many, many more years to come. What is necessary, of course, will be an understanding how these new rules will apply to existing situations. And the only conclusion that is possible is that according to the existing rules, that would not be possible. And therefore, we do need to come up with some sort of legal creativity before coming to a conclusion on whether the legal rules that exist are suitable to solve this problem. Thank you very much, and congratulations, Harry. Thank you.
Thank you. That was wonderful. And we certainly all wish we could have gone longer. Thank you. It's fascinating. Next up, Won-hee Kim, director at KIOST, which, as you know, is one of the cooperating sponsoring entities for this wonderful event. He is also senior researcher, well, prior to KIOST, at the Korea Maritime Institute and secretary-in-chief of the Korean Society of International Law. Not surprisingly, a widely recognized international scholar and leader in the field, very widely published in law of the sea, boundary dispute resolution, maritime security, and the law and practice of international tribunals. So it sounds like he's a lawyer too. So we'll look forward to it.
Let me express my sincere gratitude for giving me this wonderful opportunity to my Director General and also Luis to make this conference possible, and also deep appreciation to the Professor Harry Scheiber and Dr. Kwon Moon-sang, who is now absent due to the jet lag, but they made some bridge between Korea and Berkeley Law School. So I think it could be a great asset for a next generation like me. So I'm really happy to be part of this wonderful gathering. So today my topic is the ITLOS advisory opinion proceedings on climate change and international law. So I just put the title sounds more attractive to you, but it's a very simple presentation about what challenges are ahead before the ITLOS when dealing with the advisory opinion on climate change and international law. So as you may know, there are 3 parallel advisory proceedings before International Court and Tribunal about the climate change. The first one was the 2022 December. The Commission of Small Island States on Climate Change and International Law submitted a request for the advisory opinion before the ITLOS. It was the first, and second, last January, Colombia and Chile submitted a request for the advisory